Good morning. Good morning.
Good morning, my lord.
Yes.
My morning, my lords.
Good morning.
Let us start. Yes.
Supplementary call this under the heading for orders, serial number 1, MA number 316 of 17.
Milords,
किताब लगा
Milords, I have examined the matter, Milords. When my memo of appeal was presented before this honorable court had the jurisdiction, Milords. Now, Milords, in view of the Amendment Act 2018, Milords, now the pecuniary jurisdiction has been enhanced to the principal district
The
judge.
file will be sent back to the principal district judge.
Milords.
Uh, Take down. Okay, in view of the Bengal, Agra, Assam Civil Courts within bracket Jharkhand Amendment Act 2008. Jharkhand Act number 9 of 2018, sorry, and Jharkhand Act number 9 of 2019, and in view of the judgment passed by this court in so and so versus so and so, since the pecuniary jurisdiction of the principal district judge has been enhanced to rupees 25 lakhs,
25 lakhs, Milords.
25 lakhs, comma, this miscellaneous appeal, comma, filed under order
43
order 43 rule 1
1C.
1C
It's D, Milords. 1D.
1D. You have made it C.
Milords, it's 1D, Milords, as per the provision under the order 43.
CPC.
Milords, D reads as, Milords, an order under Rule 13, Order 9, rejecting an application in a case open to appeal for an order to set aside a decree passed ex parte.
And C.
C is dismissal for the suit.
So the suit has been dismissed.
Here, suit has been allowed ex parte against
Oh,
me.
yes. Suit has been allowed.
Oh,
My suit has been decreed.
your suit has been decreed. The suit was
My
by
suit-
you, by
by the respondent. I filed the suit. My suit was decreed. Then he filed an application for setting aside that ex parte decree.
party decree,
And that has been rejected.
party dismissal.
Yes.
But then you have mentioned 1C in your application. 1D be sent to the which district?
Bokaro district means principal district judge Bokaro.
District sent to the principal district judge Bokaro for deciding the case himself or by any other district judges having jurisdiction to hear the matter.
Oblige, Milords.
Yes, next.
Under the heading for admission, serial number 2, MA number 568 of 16, Mr. Anil Kumar Sinha.
Lordship,
Yes.
I am appearing on behalf of appellant, Your Lordship.
Yes.
Your Lordship, my submission was only, Your Lordship, that the deceased was not gratuitous passenger, Your Lordship. He was owner, he was laborer at that time when he was traveling on the goods carriage, Your Lordship.
Okay. Jharkhand motor vehicle rules. Let us see the evidence. What evidence has been led? First, come to the FIR.
Lordship.
You are the owner.
Yes, your lordship. I am owner of the truck, your lordship. May I read the FIR, your lordship?
Just a minute, let me find out the FIR. Going through your readings, you have stated that in uh, your reading, the fact that they were the laborers of the brick owner who hired the truck for transporting the brick. Yes, the FIR, please.
हमारा नाम जीतन रविदास, पिता सच एंड सच, दिनांक 10/10/2007 को दिन नामालूम करीब 8 बजे दिन में पार्वती क्लिनिक तिलैया में तिलैया थाना के जमादार साहब के समक्ष अपना बयान देता हूँ कि आज दिनांक 10/10/2007 करीब 6:30 बजे सुबह पार्टी जिसका नाम नहीं जानता है, ईटा पार्टी है, इससे कहा इसने कहा कि बाहर से ईटा ट्रक पर आ रहा है, जिसे गौशाला रोड के रास्ते डीएवी स्कूल होते हुए आगे ले जाना है और ईटा अनलोड करने के लिए कुछ लेबर की आवश्यकता है। तो ये सोमानी पेट्रोल पंप के पास खड़े और एक मजदूर को साथ लेकर ईंटा से लदे ट्रक पर कुल 10 मजदूर बैठ गए। ट्रक नंबर सचन ट्रक का चालक ट्रक को चलाने लगा। ट्रक चालक वहीं से काफी तेजी से लापरवाही से गाड़ी चलाने लगा, तो मैं और मेरा साथी चालक को धीरे धीरे ट्रक चलाने के लिए बोले, परंतु वह नहीं माना और ट्रक को चलाते रहा। करीब 7:30 बजे जब डीएवी स्कूल से आगे हराही गांव के समीप पहुंचा कि अचानक ट्रक रोड के दाहिने धान के खेत में पलटी हो गया। यह लोग सभी मजदूर ट्रक पर ईंटा पर बैठे थे। ट्रक पलटने के बाद ट्रक को ईंटा के नीचे मैं एवं मेरा अन्य साथी दब गया। खेत में पानी ना रहने लगता है, लिखा है योर लॉर्डशिप। के बाद मेरा अन्य साथी किसी तरह निकल गया, परंतु मैं और मेरे गांव के भतीजा कारू दास पिता युवराज दास ईटा के नीचे दबा रहा। तो किसी तरह मजदूर लोग हम लोग को ईंटा के नीचे से निकाला। कारू दास कीचड़ में गड़ चुका था, काफी चोट लग गया था। हल्ला पर गांव के लोग पहुंचे तो किसी तरह दोनों को पार्वती क्लिनिक पहुंचाए, जहां मेरा इलाज चल रहा है। इसी बीच थाने में पुलिस भी पहुंच गई, जहां मैं अपना बयान दे रहा हूं। मेरा गांव का भतीजा कारूदास की मृत्यु इलाज के क्रम में हो गई। मेरे अन्य साथी को भी हल्का फुल्का चोट लगा है। मेरा दावा है कि ट्रक नंबर सच एंड सच के चालक द्वारा तेजी से लापरवाही से गाड़ी चलाकर ट्रक को पलटने के कारण यह घटना घटी, इससे कारूदास का मृत्यु हो गया। मैं काफी जख्मी हूं तथा मेरा अन्य साथी मजदूर को भी हल्का फुल्का चोट लगा है। यही मेरा बयान है।
Now come to the evidence of these eyewitnesses on the facts of the accident.
लौट Your Lordship, CW1 is Santosh Kumar. And he had stated that, may I read, Your Lordship?
Yes. Who are the eyewitness? Yes, I've seen this evidence. Now, what is your arguments?
Your Lordship, my only humble prayer is that this vehicle was goods carriage vehicle, Your Lordship, and the person who was traveling at the time of accident, the deceased was laborer and not the gratuitous passenger, Your Lordship. So the issue number 7, which was decided by the court below, Your Lordship, that they are passenger, they are not passenger, they are laborer, Your Lordship.
Where is issue number 7 page?
Your Lordship, internal page 6, Your Lordship,
Internal page 6.
paragraph number 11, Your Lordship.
Let us come to that issue. Yes, read that.
Both issues are also in issue number 2 and 7. Your Lordship got it?
Yes, yes.
Yes, Your Lordship. Both issues are also interlinked to each other. Thereafter, it is taken together for adjudication. OP number 1 and 2 pleaded that at the time of alleged accident, the said truck number such and such was duly insured with OP number 3. This fact has also been indicated admitted by OP number 3. At the time of hearing, the OP number 3 has filed photocopy of the insurance policy, that is Exhibit XY, which clearly goes to prove that at time of
Lordship,
accident,
Lordship,
the
Madam Nirupma is continuously making some submission, but her voice is not coming. She is not aware of the fact.
No, no, voice is coming. I can hear it. You need not interfere. If I am not hearing it, I will tell the council.
Lordship. OP number 3 has pleaded in his written statement by paragraph 21 that without payment of premium for cover of risk of labor oblique deceased, the OP is not liable to pay compensation amount in light of FIR. In support of this pleading, OP number 3 has produced Exhibit Y, X,
OP
Y,
number 3. OP number 3 is the insurance company.
insurance company, Your Lordship.
Yes.
Further,
Yes.
it is stated that, Your Lordship, the learned counsel argued that insurance company has not received any premium from OP number 1 for cover the risk of labor. Rather, he has received the premium amount only to cover the risk of WC of employee 3. He has further argued that from perusal of the
You have unmute. You have unmute yourself. You have gone mute now.
sorry,
Yes.
Your Lordship. uh, it appears that claimant themselves admitted that deceased was traveling in the offending vehicle as a labor of bricks owner. Therefore, the insurance company is not liable to pay any compensation. The learned counsel further argued that deceased was traveling in the goods carriage vehicle as gratuitous passenger. Therefore, the insurance company is not liable to pay any compensation. My only humble prayer is, your lordship, they
Continue,
were
continue, continue this. You make your
therefore the
argument.
insurance company is not liable to pay any compensation. Rather, the owner is solely liable to pay the compensation to the claimant. In support of his argument, the learned court relied upon. There are some judgments, your lordship. And on the next page, your lordship, at paragraph number 12, on the other hand, the learned counsel for the claimant submits that even the offending vehicle is good carriage vehicle, then the claimants are entitled to receive the compensation amount from the insurance company. In support of his argument, he has filed a ruling reported in 2007, Volume 1, BLJR 539, Patna, Safiq and others versus Manas Kumar Mukherjee and others, your lordship.
Continue. Let us see the finding.
Uh, Paragraph number 13, your lordship.
Yes.
Admittedly, the offending vehicle is a good carriage vehicle, and at the time of accident, brick was loaded. Owner of the bricks was also present in that vehicle. Deceased was called by owner of the bricks. The owner of the bricks told to the deceased that there is need of some laborer to unload the bricks loaded in the truck. And on this statement of bricks owner, the deceased loaded sat in the truck and traveling. This fact has been supported by all CWS, CW2, who is eyewitness, your lordship, in paragraph 2, has clearly admitted that at the time of accident, the owner of brick was also in the offending vehicle and deceased sat on the bricks loaded in the offending vehicle, which clearly goes to show that at the time of accident, the owner of goods was present in the offending vehicle and deceased was not boarded in that vehicle as or agent of goods rather in the offending vehicle. Are all not claiming that the deceased was boarded in the offending vehicle as the employee of the offending vehicle, your lordship. Next paragraph 14. On the other hand, the OP number 1 and 2 have clearly pleaded in paragraph 5 that the deceased was engaged by the owner of bricks, but it is not admitted at the time of alleged accident he was traveling on the truck. Therefore, from perusal of this para, it is quite clear that deceased was engaged by the owner of bricks. The other part of this para is an affirmative pleading. Therefore, the burden lies on the OP to prove that cause of death of deceased was other than MV accident. But the OP number 1 and 2 have not produced any evidence in support of their pleading. At the time of discussion regarding issue number 5, this fact has already been decided that the death of deceased was caused due to rash and negligent driving by the driver of the offending vehicle. Next, paragraph 15, your lordship. From perusal of exhibit Y, it appears that this is a certificate of insurance of goods carrying other than 3WH public carrier. Goods carriage vehicle cannot carry any passenger. Section 149(2) of new act, the defense available in the insurer if the breach of condition established by the insurance company. Under new act, it would be breach of condition in case vehicle is used for the purpose other than for which the vehicle is good carriage vehicle, and exhibit Y also goes to show that the policy was issued by insurance company for goods carriage vehicle. Section 149(2) Section 149(2) clearly indicate that no liability could be passed on the insurance company if the passenger traveling in the goods carriage vehicle. He was not passenger, your lordship. Next, paragraph number 16, your lordship. The learned counsel for the claimant has relied upon the judgment passed by Honorable Patna High Court, reported in 2007, Volume 1 BLGR, page 539, Patna. In this case, the deceased was labor and the offending vehicle along with trailer was insured for agricultural purpose. Therefore, the Honorable Court has held that insurance of trailer was done with a view to carrying agricultural produce or equipment which is not possible without the help of any laborer, and further hold that the risk of labor would be covered under third party. In this case, the witness has clearly stated that the deceased was an employee of tractor owner and was working as laborer on the said tractor, which met accident. But so far the case on my hand is concerned, admittedly the deceased was not the employee of truck owner or working as laborer of owner of truck, rather he was loaded boarded on offending vehicle as labor for owner of brick. Therefore, the fact of the judgment filed by the learned counsel of the claimant is different from the facts of the case on my hand. Further, Your Lordship, the Honorable Apex Court in New India Assurance Company Limited versus Asha Rani and others, decided on 17th August 2001, has held that in a case a permit is issued for a goods carriage, it would not include any passenger. The and in case their travel, it would be contrary to the mandate of the statute, and thus in view of section 149(2), no liability could be passed to the insurance company. On the other hand, from perusal of the several rulings, findings filed by the insurance company, it appears that Honorable Apex Court as well as Honorable High Courts have clearly observed that passenger traveling in a goods carriage vehicle succumb due to goods carriage motor vehicle accident, the insurance company is not liable to indemnify the compensation amount to the owner. 2005 ACJ, page 721.
Yes,
The effect of
you can skip that. You can skip that.
the
Now come read para 17.
exhibit Y clearly states that insurance is only for carriage of goods and does not cover use of carrying passenger other than employee, not more than 3 in number, coming under the uh, purview of the 1923 Act. On the bare reading of the Exhibit Y insurance policy, there can be no iota of doubt that the policy is related to the insured and it covers 3 employees and it is statutory in nature. It neither cover any other category of person nor does it increase any further liability in relation to quantum. Considering the above facts, circumstances, and discussion made above, coupled with the several decisions mentioned above, I come to the conclusion and hold that the occupant of vehicle deceased was not covered under policy. Paragraph 18,
Yes.
Your Lordship. So far, issue number 7 is concerned. At the time of deciding the issue 2 to 5, it has already been decided that at the time of accident, the deceased was traveling in the offending vehicle. The accident was occurred due to rash and negligent driving of the driver of the offending vehicle. Therefore, claimants are entitled for compensation from the owner of the offending vehicle. And after that, the quantum has been decided, Your Lordship. We are not going to the quantum, Your Lordship. We are only confined to the whether the liability goes to the insurance company or the owner of the truck, Your Lordship, as the deceased was the laborer and not the passenger, Your Lordship.
Yes. Yes, Mr. Ghosh.
My lord,
Yes.
my lord, the may I reply, my lord?
Yes, yes.
From the claim application as well as from the FIR, it is clear at the time of occurrence, 10 laborers boarded the truck. Now, the, the truck was coming from a certain place and was going to a certain destination. And just before reaching the destination, the truck stopped. The owner of the goods was on the truck. He come down and collected some people, laborers, from the road and asked them, I have to unload the vehicle, please come up. And thereafter, these 10 laborers got on the truck. So, the benefit of owner of the truck or the representative of the truck or as an employee under the WC Act cannot be extended up to these persons, 10 persons, and deceased is
It's
one.
only one person because it will be extended to the person who is dead.
G. But
Yes.
the deceased was picked
Now-
up from the road
Mr. Ghosh,
by the owner of
Mr.
the
Ghosh, one point. Mr. Yes, yes, Mr.
Fine.
Ghosh, on one point, from this finding of issue number
Yes.
7, the court has found that he is not the employee of the owner of the truck. This is a conclusive finding which the court has arrived, tribunal has arrived, that he is not the employee of the owner of the truck, so he cannot be said to be a workman of the owner. There was
Yes.
no employer-employee relationship between the driver of the owner of the truck and this deceased. But
Yes.
the tribunal has also given a conclusive finding that this person was an employee of the owner of the goods who had taken the truck on hire.
Yes.
In that view, section rule 125 of the Jharkhand motor vehicle rules, what do you have to say?
None. Well, this rule 125 of Jharkhand motor vehicle rules is in chapter 5 of the said rules. This chapter is not a charging chapter, either by way of tax or by way of premium for insurance of the vehicle. It is control of transport of vehicle. It is regarding the control of transport vehicle. And in this chapter, this particular rule is only saying that if this owner of the goods or his representative is carried or going on with the goods, then he will be carried without any charge. This section is
So
saying nothing or not casting
I,
any duty upon the insurance company that the
no, I am
insurance
asking you to
company
say one
would.
thing. I'm just referring to this for the reason
My
that
lord.
the tribunal has held that since he is not an employee of the owner of the truck and is an employee of the hirer of the truck or
Yes.
and the owner of the goods, employee of the owner of the goods which was being transported, he holds that. Then after holding this, can the tribunal say that he is a gratuitous passenger?
But here the owner is present in the
Maybe
vehicle.
where it says that in the presence of the
And,
owner, the
and yes, yes. And risk of the owner of the goods is not covered by way of statutory provision. The risk of owner of the vehicle, simply one person or his representative, not representatives, a single
no,
person
I'm saying that
is covered.
123, 125 says, provided the owner or the hirer of a bona fide employee of the owner or the hirer of the vehicle may be carried free of charges or a police officer in uniform. It does
Yes,
not say bona fide employee, it does not restrict to only one employee. Because you see, it is one for a light motor vehicle
yes,
and it is three for any other light goods carrying vehicle, five in case of the medium goods carrying vehicle. So
yes.
it cannot be said that it will restrict it to only one.
Malad, it is a totally different provision from section 147.
Are you challenging the constitutional validity of this?
No. I'm just
Then
pointing
it's a
out the
different matter.
difference
Then
in
it's
between
then
the
it's a
provision
different
of the
matter.
act. Of course,
See,
of course,
let
Malad,
us see
this
147. See this motor vehicle act. This motor vehicle act and rules. If you see, uh, give me the constitution. Constitution of India.
had the owner of the vehicle was not present in the vehicle, in that case, the case is different. Rather, in favor of
Even
the
if he's
claim,
present, even if he is present,
then his risk is covered.
no, it says that they are they
Here,
are
the
they are
my lord,
allowed to carry. He can. My question is, he's not a gratuitous passenger. Whether
the
the court can,
laborer of
whether the tribunal can say that he's the uh, gratuitous passenger. This is my question to you.
here the owner of the goods is going with 10 laborers, full battalion,
Yes.
and the deceased person got in the vehicle of in the midway.
Yes.
Of course, the deceased is the laborer of the owner of the goods.
Yes.
And the last sub-rule 6 of section 125 itself is
Yes.
saying no person shall travel in goods carriage in contravention of the provision of this rule.
Yes.
Yes. Therefore, even if it is assumed that this section is meant only to give some relief to a passenger or laborer, whatever, that a certain fare will not be charged against him by the owner of the vehicle. In that case also, only one person, the owner or the hirer or a bona fide employee of the owner or the hirer of the vehicle may be carried free of charge. Perhaps, my lord,
Yes.
this is something different from section 147.
149.
147 read with 149.
Read 147.
Requirements of policies and limits of liability. 1. In order to comply with the requirements of this chapter, a policy of insurance must be a policy which A. is issued by the person who is an authorized insurer, and B. insures the person or class of persons specified in the policy to the extent specified in subsection 2. Then B Roman 1, against any liability which may be incurred by him in respect of death of or bodily injury to any person, including owner of the goods or his authorized representative carried in the vehicle, or damage to any property of a third party. Against any liability which may be incurred by him means the insured, or in respect of death or bodily injury to any person, including the owner of the goods or his authorized representative.
Yes.
This is the
Sorry. Not with it.
जो इसमें सेक्शन 147 में इस डिसीज्ड को कवर करना शायद परहैप्स इट इज रिमोट, मेरा सबमिशन है रिमोट चांस, अदरवाइज
Madam, uh, a question
Lordship.
may arise, a question may arise that you may not be a gratuitous passenger.
Yes, Your Lordship.
You are not a gratuitous passenger. But the question is, you are you are not a gratuitous passenger because of section rule 125.
Yes, Your Lordship.
But the question, the second question, which will need your address, is whether can it be said that you are covered by the policy? Because you go through this judgment, 2014, volume 14, SCC, page 243. Because the facts is similar to your case.
Yes, yes, Your Lordship.
Owner of the goods was carrying the good along with the laborers of the owner.
Yes, yes, Your Lordship.
Owner nor the laborer were covered. It was only the coverage was 5% or 6 employees of the insured. The Honorable Supreme Court says that the persons who are not covered will not be entitled to get compensation from the insurance company since they are not covered. Over here, you may not be a gratuitous passenger, but if you are not covered, can the insurance company be directed to pay the amounts? This is my question.
Third party insurance is there, Your Lordship. Am I not covered by the third party, Your Lordship?
Deceased was in the vehicle.
Says the Honorable Supreme Court says that any injury to any person in section 147(1)(b) would mean a third party and not a passenger person traveling in a goods carriage, whether gratuitous or otherwise. Or otherwise. So even if you are not gratuitous, you are otherwise. So the Honorable Supreme Court says a person who is traveling in a goods carriage vehicle, even if he is authorized, he cannot be said to be a third party by virtue of this judgment.
I may be wrong, Your Lordship. May I submit one thing? There are three categories of employee. First is driver, another is conductor, and third is any other persons who are on the goods carriage, Your Lordship.
Whose employee? Whose employee? Employee of whom? You have to address this also. You have to see this employee of whom. You may not be, you are right. You are not a gratuitous passenger.
Yes, yes, Your Lordship.
In that, on that issue, prima facie, I think what you have submitted, in view of the rule also, you are correct. You may be correct that you are not a gratuitous passenger. Then, if it would have been a passenger carrying vehicle, the matter would have been absolutely different. It would be a third party. But vis-a-vis a goods carriage vehicle, whether an authorized passenger not being insured can be said to be a third party. His judgment is directly coming in your way.
If Your Lordship may permit me, I will, uh, and give me 1 or 2 days time, Your Lordship, I will be able to assist Your Lordship on this point, if Your Lordship may permit. Any other date may be given, Your Lordship, then.
See, para 23 of this judgment, I'm reading it for you.
Yes, Your Lordship.
A policy, a policy is not to state here that the proviso commences on a different way. A policy is not required to cover the liability of the employee except an employee covered under the 1923 Act. That means the Workmen's Compensation Act.
Hmm.
And that too in respect of an employee carried in a vehicle. To put it differently, it does not cover all kinds of employees. Thus, on a contextual reading of the provision, a schematic analysis of the Act and the 1923 Act, it is quite limpid that the statutory policy only covers the employees of the insured, either employed or engaged by him in a goods carriage. Now, next is important. It does not cover any other kind of employee, and therefore someone who travels not being an authorized agent in place of the owner of the goods and claims to be an employee of the owner of the goods cannot be covered by the statutory policy, and to hold otherwise would tantamount to causing violence of the language employed in the statute. Therefore, we conclude that the insurer would not be liable to indemnify the said insured. This is also a case under the Motor Vehicle Act. Even this judgment is from another state. So the Jharkhand motor vehicle rules were not under consideration. But even if this rule 125 is taken into consideration, then at best it can be said that you are not a gratuitous passenger but a passenger. But in view of this, the Honorable Supreme Court says that also needs a coverage. Let us see the policy. Where is the policy?
Exhibit Y.
Yes. Where is the coverage, Mr. Counsel?
On the top, it was written, Your Lordship, it is a package policy, Your Lordship. Right side on the top of the policy, it was written package.
Where is it?
The New India Assurance Company Limited, Patna Region Office. Then a header line is there, Your Lordship, and just below that line, package, it was written, Your Lordship.
No, the photocopy which I am having. What is package means? Over here also the package, the word package will also not help you. Maybe own damage also.
Yes,
You
Your
are not
Lordship.
covered under the own damage also. Who are covered? Mr. Ghosh,
My lord,
which page? Yes, WC to employee. That means workman's compensation. Workman's compensation means employer-employee relationship between the insured and the deceased should be there. And admittedly, there was no such relationship. Your relationship was with that of the owner of the goods.
I don't have that judgment, Your Lordship, but it was decided in Kerala High Court judgment, Your Lordship, National Insurance Company versus Muhammad Ali and others. But I could not find the judgment. I have only the citation, Your Lordship. Through net, I have saw it, Your Lordship, and it was written in this. The court held that in the third-party insurance policy, the contract of insurance must provide the coverage in respect of death of bodily injured caused to three categories of employees, that is, drivers engaged employee, second, conductors of the public service vehicle or persons examined as ticket examiner, and third, any persons carried on a good carriage, Your Lordship.
That or any persons carried on a
Goods carriage, Your Lordship. Any person carried on a goods carriage.
no, that can't be. That can't be because section 147, 149 and read with this judgment.
May I take assistance with Mr. Lal, Your Lordship, if Your Lordship?
You may.
My lord, as because I have just joined, my lord, I am not aware of the fact.
I'm adjourning this case. You are praying for some time to go through the judgments.
Yes, yes, Your Lordship.
Uh, let it be on Monday,
Monday is holiday, perhaps.
holiday. Now let it be on Tuesday.
Tuesday, I am out of my lord.
You are-
Any day after Tuesday, my lord.
No, this is not your case, Mister. Tuesday,
my lord.
My Lord.
5th, heard in part for further hearing on 5th on the request of the learned counsel for the appellant. Yes, who is for the claimant? Who is for the claimant?
Yes, yesterday Mr. Achinto Sen was appearing, Your Lordship. Perhaps today he has not joined.
No,
I
no,
don't know the
he has just he has joined. Was present.
Okay.
I have seen from the screen.
Judgment not
Lordship,
Yes.
Lordship, there is some network problems. That's why.
What do you have to say? There is a judgment of the Honorable Supreme Court exactly on these facts.
Lordship, admittedly, the deceased was died in an accident. That is not in dispute.
Yes.
Now, whether he's died in an accident, so he's entitled for the compensation, the legal here.
There's no doubt about it.
That is
Since yesterday you had taken the side of the owner that insurance company will have to pay. Now I'm asking on this issue.
Lordship, actually, he is not a gratuitous passenger as per section 125.
Yes, he's not a gratuitous passenger. Even if he's not a gratuitous passenger, the Supreme Court judgment says that he is not entitled to receive because he is not covered. He cannot be said to be third party.
On one thing, Lordship, their fathers, the respondent herein 1 to 5, their mother also died during the pendency. All are minors, Lordship. That's why I am supporting them so that they should get some amount. That's why I am saying that insurance company should pay. If the owner is to be paid, liability is upon the owners, then I will pay one thing, pay and recovery should be done in this case.
Mr. Ghosh,
My lord.
now what is the judgment the owner has to pay?
Here the appeal has been filed by the owner of the vehicle.
Its right to recovery was granted or not? You had, it was the
No,
owner.
right.
Okay.
The right of recovery has not been granted. The entire liability, impact and incidents of the liability, both, they has been shifted upon the owner of the vehicle. Regarding right of recovery, that is some
Running page,
para 13 में
running page 30,
that has been
internal page 10, ordered.
Yes.
It is hereby ordered that the claim application is allowed on context against the defendants. OP, the plaintiff's applicants are entitled for compensation of rupees 3,54,000 along with interest at the rate of 6% from the date of filing of the claim application. Date is 18/1/2008 till realization in equal shares. The OP, defendant number 1, is directed to pay the compensation amount to the plaintiff number 1 to 5 through check or demand draft within 30 days of this order, failing which the claimants are entitled to recover this amount through process of law with penal interest at the rate of 9% from the date of filing of the claim case.
This 9% is this within 1 month and otherwise 9%. This is bad.
Next. This is important. Next page, Lordship. Since claimants number 4 and 5 are minor children and their elder brother.
I'm asking it is not that pay and recover. It is directly to be paid by the claimant.
Directly claimant. Owner.
On Monday.
So
Lordship.
my prayer is paid Monday, Lordship. Monday, I think there will be holiday.
Tuesday.
Rule.
Oh, sorry, Tuesday.
Lordship says Tuesday.
Tuesday.
Yes, Your Lordship. Obliged.
You go through that judgment.
Yes, sure, Lordship.
subject to my lords. My lord, the claimant is present. Claimant may file a simple affidavit that their mother has expired. The court judgment is still not passed in this appeal. In the meantime, if my lord pleases the claim,
Mother is a party.
claimant has just said that the mother has expired. Therefore, I am saying.
Just switch on.
Lordship, this has come in the judgment, page 22, internal page 2. Shanti Devi died during
Mother
inquiry.
is not party, Your Lordship.
Mother is not a party.
Mother is not party.
Lordship, just a moment. During the inquiry, the claimant number 1, Shanti Devi, died. Her name was deleted, white order, 12/4/2010. So her mother died. That is, that is itself in the order sheet.
Okay.
Accordingly, she was not a party.
Before passing of the award.
Obliged, your lordship.
Yes. Yes.
From Delhi causes, under the heading orders with defect, serial number 1, cross objection 2 of 16. Mr. Amit Kumar Hotel.
Yes, Your Lordship, I am pray for 2 weeks time for removing the defects, Lordship.
To remove the defects.
Oblige, Your Lordship.
Serial number 2, MN number 54 of 16. Mr. Devendra Kumar Sahu for the appellant.
Yes. 2 weeks to remove the defect. No one appears.
Under the heading for orders, serial number 2, MN number 386 of 14. Mr. Amit Kumar Das for the appellant.
My lord, in this case, my lord, the IN number 6466 is for consideration of your lordship, my lord. My lord, it relates to the order dated 3rd of August 2021. Lord, your lordship may kindly see the order dated 3rd of August 21 that is attached with the IN.
Yes.
Mr. Ganesh Chand Jha, advocate, accepts notice on behalf of the respondent number 4. 3rd of August.
Yes.
Let 2 copies of the memo of appeal along with the award that we have complied. But the second part, the entire amount of compensation is directed to be deposited before the tribunal within 3 weeks. This was the direction. In case the appellant succeeds, थोड़ा सा यहीं पर confusion हो गया है. In case the appellant succeeds in this appeal, the insurance company will be reimbursed by the same. हुजूर कहना चाह रहे थे कि insurance company will reimburse the appellant.
B has to be deducted.
B हाँ तो and the same का जगह पर appellant. B has to be deleted.
There's a typographical error in the order dated 2021. In the last line of the order dated 2021, full stop. It is mentioned that the same be read as follows within inverted comma. In case the appellant succeeds in this appeal, comma, the insurance company will reimburse the same.
My lord, I am the appearing of behalf of the claimant, my lord. One direction may be given, my lord. The claimant is
will reimburse the same.
The
date to the appellants.
My lord, I'm the time has to be extended, my lord.
You deposited it.
No, my lord. Since we have to not get back, my lord, the order clarification was required, my lord.
No. The entire amount of compensation is directed to be deposited by the tribunal within 3 weeks. This line did not.
No, but the clarification.
There was no clarification for that. For why didn't you deposit this amount?
I am the appearing of claimant, my lord.
Just a minute, Mr. Kumar. Why didn't you deposit that amount when this line was not to be clarified?
My lord, that's why, my lord, we have said, my lord, that this.
Deposit it.
My lord, time only few time, my lord, further time, my lord, so that since the clarification
was been deposited, if the amount has not been deposited, the same must be deposited within a week.
Some more time, so that we may communicate them, my lord.
No. It's 3/8/2021. It was ordered.
My lord,
and that deposit need not. It was not to be verified.
My lord, we filed the IA, my lord, immediately when we
you filed your IA. What's your IA in respect of deposition of this amount for clarification? If you want a clarification that you will deposit by check, draft, or then this line, the entire amount of compensation is directed to be deposited before the tribunal within 3 weeks. It was not necessary for any.
2 हफ्ता या 10 दिन कर दिया जाए ना, उससे ज्यादा नहीं कर.
एक हफ्ता. And I know if you will give a call today, it will be deposited tomorrow.
My lord,
विकास
I
सर
submit
रोल ये सब है
submit one
इसीलिए
thing, my lord. My lord, I am submit one thing, my lord.
Yes.
I am submit one thing, my lord. Please direct the claimant to entitle the check payment, my lord.
No, that you will have to make application there.
This is not
That
the way. This was only referred for the purpose of उसके बाद देखिए list this case before the appropriate bench as per the roster.
Right. All right.
The order has already been the order has now already been clarified.
Right.
I disposed. As this case was listed and assigned before this court, only for deciding the clarification application.
My.
Yes. Next.
Number 358 of 15, Mr. Gautam Kumar, Mr. Sandeep Kumar Bandwal, for appeal.
My lord, one IA.
Yes.
Lordship, that IA number 6643 of 2021, Lordship. For reducing of additional evidence, Lordship. The documents which have been sought to be. My lord.
Why should I allow you?
Lordship, on last date, my lord, today I have sent one judgment, Lordship, recently passed by the Honorable Supreme Court, Lordship, in a case of Sanjay Kumar Singh, my lord.
Now, the question is, this is, yes, Mr. Ranjan Singh, what do you have to say? Switch on.
Sorry. So far, that very point is concerned, my lord. So that has already been dealt by in the impugned judgment itself, my lords. And apart from that,
whether these documents have been dealt with,
not these particular documents. So far, the identification and status of the petitioner applicant is concerned, that has been dealt by the impugned order by way of various documents. It appears from paragraphs 26, my lords, of the impugned judgments.
I have seen that. But Mr. Ranjan Singh, this is a declaration by the husband stating that Balmadina Hansda is the wife.
My lord.
Now this document, it was not within his, not in the position of the appellant, and as per the law, Order 41, Rule 27, B, the court can. But these are the photocopies.
Yes.
The original has to be exhibited. That has to be in terms of the Evidence Act. This is how the document has to be.
That's true. But so far as one, I would like to draw your lordship attention, the judgment which is referred by my colleagues, wherein it has clearly dealt in paragraph 4, my lords, the just last 3-4 lines, my lords.
Yes.
It is fourth line, my lords, third line in paragraph 4th, my lord. It is further observed that the true test, therefore, is whether the appellate court is able to pronounce judgment on the material before it without taking into consideration the additional evidence sought to be adduced. So my
question to you is,
Whether
the true test is whether the appellate court can pass a judgment. What do you mean by the word judgment here? Judgment, just ixi judgment, or a judgment in true sense which decides the issue really taking into consideration? A judgment can be passed with evidence also. A judgment can be passed on without evidence also, but will that be a correct judgment? The judgment should be as far as practicable and possible, taking into consideration all the aspects. Will it be said that if I pass a judgment, and more so, Mr. Singh, whether this document, if it is taken into consideration and admitted in exhibit, will change the judgment of the trial court. If there is a possibility, a remote possibility that the judgment may be changed, or
My lord.
then why it should not be accepted? Tell me.
Yeah, yes, my lords. My simple prayer with this manner, my lords, there is, it is an admitted fact that my client is also the wife of that very deceased, my lords. Now the question is whether this appellant is the, in fact, the wife of that very deceased person or not, my lords. And so far, by taking into consideration the other material also relating to
No,
the,
Mr. Singh, Mr. Singh, in your
my lords.
case, the son, the son was given a share.
Yes, yes,
The son was
my
given a
lords,
share. That means, just a
my
minute.
lords, my
That
lords,
means the
my lords,
court, the court
my lords,
has held that he is the son of the deceased through this
my lords,
wife, through this
my
through
lords,
this lady.
my lords,
Now,
my lords. That's
now,
true.
now, question is the status of the son is the son of the deceased through this lady that has been
My
accepted.
lords,
Now, the status
my
of the
lords.
lady has to be decided.
Determined. My lords.
Now, the question is the prima facie when the court has held that he is your son through that lady. Uh,
My lords,
then the first natural presumption would be that he is the wife.
my lords,
If
my lords.
it is
Certainly, my
not
lords.
rebutted, now
My lords.
he is now trying to bring on record the document addressed by him to his employer, giving this lady a status of his wife. Now then,
My lords.
on Friday for orders on the IA.
My lord.
Let me decide the IA
Obliged.
first.
My lords.
भेज दीजिएगा फाइल.
Obliged, my lords.
I have sent the judgment, my lord.
Yes, I'll take it.
Serial number 5, MA number 77 of 16, Mr. Ashutosh Anand for the appellant. Big serial number 6, MA number 76 of 16, Mr. Ashutosh Anand for the appellant.
Yes, Mr. Ashutosh Anand. Where is Ashutosh Anand?
My lords, I'm sorry, my lords.
Have you satisfied
My
the
lord,
award?
my lord, in this case, I've received the copy of the, I've received the report of the investigator when the details of the legal airs have been come, my lords. I'll be filing it within, my lords, 2 days, my
Have you
lords.
satisfied the award? Have the order dated 22/3/2021 has been...
I'm extremely sorry, my lord, but because the details were not coming forward, my lords.
No, no. That means you have not satisfied, you have not complied the order dated 22/3/2021.
Oh, my lords, I need to take instruction with regard to that, my lords, whether the...
For that 1 year has passed. For that 1 year has passed.
My
Time
lords.
was granted to you on
Just, my lords, 1 week's time, my lords, I'll come up with both these, my lords. Just 1 week time, my lords.
22. Together, even after expiry of 1 year, the counsel for the appellant is not in a position to confirm as to whether the order dated 22/3/2021 passed in this case has been complied or not. Full stop. List this case on. 8th of April.
My lords.
It is made clear if the order is not complied by then, an appropriate information has not been forwarded to this court, comma, the appropriate punitive order will be passed against the appellants.
My lords.
Same, along with.
Serial number 7, appeal number 391 of 16.
But in this case, on the last date of, that is on 23rd, they have served me the copy and they have said, I have forwarded the copy to the insurance company. But I am not aware to whom they have assigned the brief. Let it come after on 11th or something like that, so that I'll be able to ascertain and inform them that this case was listed today.
What is the IA?
But I'm not aware because the entire bunch has been sent to the insurance company.
Lord, I am appearing for the side of the appellant, Lord. And
Yes.
since I am in hospital, Lord, and this illness, I need 2 weeks time, Lord. Adjourn. The case may be adjourned for 2 weeks, Lord.
This case is adjourned for 3 weeks as the counsel for the appellant uh, is uh, is suffering from some illness.
Obliged, Lord.
Serial number 8, MN number 578 of 16. Mr. Ashutosh Anand for the appellant.
Yes, Mr. Ashutosh.
My lords, in this case, earlier notices were issued, my lords, upon R1, my lords, and we had submitted the notice on 23/2/2022, my lords.
Mr. Ashutosh,
My lords.
just inquire whether the counsel who submitted just the case before, he was addressing this court from the hospital.
I'll just check up, my lords.
Just check up, and if it is correct, just warn him. Tell him that this is not the proper way.
My lords.
But this is what he said, my lord. He said he was in hospital.
He should have, I think, I don't know, I may be.
No, he did not start the video, my lord, therefore.
Yes, that is why I thought that I was in hospital, he said, or he's in hospital, that confused a bit.
He said that he was in hospital, my lord.
I didn't say that he is or was, that there was a confusion, but the video was not on that. That's why I am. Just check it, and if it is there,
My lord, we'll take care of it, my lords. We'll take care of it, my lords.
warn him the appropriate procedure would have been to inform some of his colleagues.
Definitely, my lords.
Take time on his behalf. Just, yes.
My lord, in this case, earlier notices were directed to be issued, my lord. We have submitted the notice upon R1, my lords.
I am appearing. R1 oriental.
R1 has appeared.
My lords.
Yes, now what is this for orders? Why it is for orders? There's a limitation? No.
No, my lord, there's no limitation, my lords. My lord, there's a recovery right, my lords, and notices were also issued upon R2, my lords. Perhaps with regard to that, something might have come.
Who are
I'm
you?
My lord, I am the opposite parties, my lord, appellants, my lord. There's a recovery right.
You are the owner, claimant, driver.
Driver.
My lord, I am the owner and the driver. There's a recovery right granted in favor of the insurance company. I'm assailing that part, my lord.
So your relief is not against the claimants.
My lord, per se it is not, my lord.
So tell me what.
No, he has taken point, my lord. He has taken the point that claimant was not traveling in the bus. He claim is not genuine. He has taken these points in the appeal.
My lord.
He cannot say that he has no case against him.
What is your ground? Tell me.
My lord, the tribunal has heard in holding.
Show me the finding.
My lord, in this case, the entire bus was booked for going to a Bharat party, my lord.
Okay.
And so this became a contract carriage, my lords. This is what the learned tribunal has held, my lord.
Okay, is the LCR has been received?
No, my lord. LCR has not been called for, my lord.
This is under the heading for admission. as the insurer of the vehicle has already appeared. Full stop. Go for the lower court records in the meantime. You inquire the fact, Mr.
My lord,
Ashutosh.
I'll just do it, my lord.
Is this? Who is our one? Payment should be the claimant, not now. Unnecessary, the claimant should not be called. And the dispute is between the owner of the vehicle and the insurer.
Serial number 9, MA number 584 of 60.
Mr. Manish, in that case, you also seek instruction whether you have satisfied the award or not.
Yes, I will seek instruction.
You'll seek instruction. Yes. 9. Who is
My lord.
Yes.
My lord, earlier my lord, notices were issued upon respondent number 9, my lord.
Yes.
Dono, by both process we will have to take, my lord. Perhaps only ordinary. By tomorrow I will take, my lord.
This is a will.
Yes, my lord, for grant will, my lord. Admitted miscellaneous appeal, my lord. By order dated 27/2/2017.
Will was probate was granted or rejected?
My lord, partly allowed. For grant of letters of administration was partly allowed, my lord, with respect to property mentioned in Schedule A of the petition. And this letters of administration was filed by Ashim Kumar Bhattacharya, my lord, respondent number 1, my lord.
So it was granted. Against that grant, you have approached.
My lord.
Counsel for the appellant submits that due to inadvertence, he could not file the requisites for service of notice by registered cover. He submits that he will file it by tomorrow.
By tomorrow.
By Friday.
My lord.
Full stop. The office is directed to accept the said requisite and proceed accordingly.
Deeply obliged.
Serial number 10, MA number 652 of 16, Mr. Vijay Kumar Sharma.
Yes, Mr. Sharma.
I am for the respondent insurance company, Your Lordship. Last occasion on 16/2/22. Your Lordship has passed an order, call for the LCR, Your Lordship. If LCR has come, then it has to be seen, along with case number 3 of 06 and 13 of 12 Chatra. Because in this case, Your Lordship, the claimant could not establish the bona fide, Your Lordship. That's why the case has been dismissed.
LCR of claim case number 13/12.
13 to 12 and 3 of 2006, Your Lordship.
Why 3 of 2006?
I don't know. Perhaps
6 of 2013. What was the 6 of 2013? Why 6 of 2013?
Well, they have submitted that 6 of 2016 was also 13 was also filed in the same case. Lordship, whether LCR has come.
Played LCR of 6 of 2013. 6. It says 6 of 2013. PNK 6 of 2013.
Under section 130, 140, Your Lordship. Perhaps.
I want to see that. Of 14. Who has got up to 58 of 14? कितना केस नंबर है? क्या भेज दिया? ये तो 5 in reference to 535 of 69 है. ये तो 535 नहीं है. This case ये क्या है आगे? इसमें देखिए दूसरा केस में 535 का. This is from Chatra.
Yes, Lordship. In para 11 of the judgment, the reference has come.
Yes, that is why I had called for the other recording.
Yes, Lordship.
6
I
of
have yes, I have
I had called for 6 of 13 and 13 of 12.
13 of 12, they impugned order, Your Lordship. Under section 166.
So 13 देखिए.
Yes, Lordship. In impugned order, Your Lordship, judgment, it has been shown that there is.
Chikti, where is the letter which was sent by this court for forwarding the copy? Where is the letter? Just file. There is no letter. Where is letter number 671, capital A, dated 22/2/2022? Where is that letter? Six of 11, it has been mentioned 6 of 13.
Yes, Lordship.
But I think it should be 6 of 11.
6 of 11 होना चाहिए.
Before the third ADJ.
Lordship, there are series of discrepancies in this case, Your Lordship. That's why in memo of appeal, paragraph 7, Your Lordship. For that, the learned tribunal failed to appreciate that the death of the husband of the claimant, then she was resided in Naihar, and the claim case number 6 of 2011 had been filed by the uncle of the deceased. And when she know about it, she has filed the petition under Order 1, Rule 10 of the CPC for made the party of the claim petition. Earlier, she has filed the claim case 11/2004, but unfortunately it was dismissed for default. And during course of the investigation, the investigator of the company has found that occurrence was occurred and not denied, but finding of the tribunal is not just and proper. So there are a series of discrepancies, Your Lordship, with regard to postmortem, date of accident, heirship certificate, age of the deceased. That lady says that I was married 16 years back, but she said deposed that my daughter is 20 years of age. These are the findings, Your Lordship. That's why the court has disbelieved. And the heirship certificate also filed by the Mukhia from another village, Your Lordship. All these things are there. That's why the case has been. Considering the claimant has failed to establish that this was traveling in the Sahu bus. Their accident was between two buses, one Sahu bus and another Jyoti bus. Sahu bus was insured with us and Jyoti was with the Oriental Insurance Company. In case number 6 of 2013, the name which has been mentioned, I have an advantage to go through the order dated 6/9/13 passed by the tribunal in claim case number 6 of 13 under section 140 of the MV Act. And it is found that claimants had during the trial of the claim petition impleaded Oriental Insurance Company Limited as a party. However, it is quite strange that the Oriental Insurance Company has not been impleaded in this case as a opposite party. Likewise, Exhibit 1, that accident took place due to negligence act of the drivers of Sahu bus and Deep Jyoti bus. Exhibit 2 reveals that after due investigation of the accident, police recorded finding that the drivers of both the buses were at fault at the time of accident, because of whose negligence the said accident took place, but neither the drivers of the buses nor the इंश्योरर ऑफ द साहू बस वाज इंप्लीटेड एज पार्टी. सिर्फ एक कंपनी को बना करके छोड़ दिए. देयर आफ्टर लॉर्डशिप नेक्स्ट पैराग्राफ, द क्लेमेंट्स हैव नॉट proved any proof regarding heirship of the deceased person, though the witness have stated that the claimant are the legal heirs of the deceased.
No one appears on behalf of the appellant. Full stop. In the meantime, the of motor accident 2011, which was disposed of 6/9/2013 by the District and Additional Session Judge 3 at Chatra.
Serial number 11, MN number 26 of 17, Mr. DC Jha for the appellant.
Yes, Lordship. It is a case of injury, Your Lordship, as per the claim application.
By my orders.
Lordship, the notices were issued upon respondent 1, 2, and 3. Twice notices has been issued.
3 has appeared.
3 has appeared, Your Lordship.
Who is 3?
3 is the owner of the vehicle. 3 is the owner of the vehicle.
1 and 2 are the claimants.
Lordship, I fail to understand why 2 has been made a party. When the case of injuries, there a person who has short injuries was 19 years of age. Why his father has been impleaded as a party? Though he was impleaded in the court below, that's why I have also named him. But it is a case of injury. It is not a case of death. Rahul SK, son of Samuel SK, alias Samuel SK, aged 19 years. He was a claimant. And number 2 is Samuel SK, son of late Abdul Haq. Both are residents of the. This one too is the father. So in injury case, Your Lordship, I don't think father's presence is necessary. When the injured is if he could have been minor, then I could have been understood. And secondly, Your Lordship, as per the order dated 2/11/2018, we were directed to deposit 4 lakhs rupees. I have sent instruction, perhaps it has been deposited. That reflect in the order dated 10/1/2020.
Yes, it has been deposited.
Yes, Lordship. Now, Your Lordship, in this case, because the case of injury, lower court record is must in this case, Your Lordship. Without lower court record, because as per the claimants, imputation.
There is the report of the Secretary DLSA pursuant to the last orders, pursuant to the order dated 27/1/2020.
Okay. 10/1/2020, Your Lordship.
10/1/2020. As per the report, the claimants stated that if an advocate of his choice is not nominated by the DLSA, then he will engage his own lawyer. Considering the aforesaid fact, this court holds that notices about this case has been properly served upon the claimant. Claimant has not appeared. The claimant has not appeared.
The name of 2 advocates is appearing, Your Lordship, but I don't know.
No. Yes, Mr. Arafat, you are appearing? Who is appearing? Mr. Arafat is appearing on behalf of whom? Yes. What is your ground, Mr. Jha?
Lordship.
What is your ground?
Our ground is that it is a case of injury and amputation of right leg from the knee, below knee, Your Lordship. And age of the deceased was 19 years and he was a rickshaw puller. And his income has been taken as 9,000 rupees per month, Your Lord, without any of the Lordship. So may I pray, Your Lordship, lower court
records. Yes. This case under the hearing for admission.
Yes.
Yes, Mr. Arafat, you are appearing on whose behalf in this case? Switch on your microphone. Yes, sir. Mr. Arafat, switch on your microphone. You have muted yourself.
Lordship, I appear the serial number 11, Your Lordship, MA number 26, Your Lordship.
Yes. You are appearing on whose behalf?
I am appearing on behalf of Your Lordship, respondent number Rahul Sheikh, Your Lordship.
Who is Rahul Sheikh?
Clement. He's Clement.
Clement, Your Lordship.
One claimant, full stop, then right. Mr. Yasir Arafat has already put in his appearance on behalf of the claimants. Full stop. There's this case under the hearing for admission or for the lower court record. Oh, there's a limitation. There's a delay of 7 days.
7 days. Apply.
Yes, Mr. Arafat, what do you have to say?
This is Your Lordship, the case is the disability of the 60%, Your Lordship.
There's a delay of 7 days.
No objection, Your Lordship.
Yes?
No objection, Your Lordship.
Delay condoned in view of the statement made in source. Yes.
Serial number 12, MN number 54 of 70, Mr. DC Ghosh for the appellant.
I am appearing for the claimant respondents. Also.
Yes.
It appears that it is under heading of orders, some limitation petition must be there.
Who is appearing for the respondents?
I am appearing for the claimant respondents.
Who is for the
Mr. Ghosh is appearing, Mr. DC Ghosh. Through him, the appeal has been filed.
Mr. Ghosh? Where is Mr. DC Ghosh? Pass over. Tell him to connect.
Yes, yes. I will inform him.
Serial number 30, MN number 77 of 70, Mr. Alok for appellant.
But in this case, I am appearing for the appellant. The limitation application has been placed before Your Lordship for final consideration. The notices were issued and it seems that all the respondents have put up their appearance.
Yes. Who is appearing?
My lord, I am for
appearing
the
on behalf
respondent
of claimants, Your Lordship.
How many days?
Delay is 403 days, perhaps, subject to corrections, as per my calculation, Your Lordship.
Tell me why it should be condoned.
Well, of course, there is some latches because the file got misplaced while in transit from taking opinion from the RO at Patna. Because we are the government of India undertaking an original office at Patna. So for filing any appeals or satisfying the award, the file is to be routed through the Patna regional office by the concerned branch to the divisional office. Then it is sent to the Ranchi TP hub, which has not been constituted. So on that basis, we are get the file gets delayed and at times lost also in transit mode. Certain papers are missing. So these are the hassles which we are facing. And there is no deliberate and intentional delay. We have stated in from paragraph 3 onwards of IA number 1325 of 17.
No, there is huge latches on your part.
The file got misplaced, therefore we could not file an appeal immediately thereafter. Otherwise there is no such delay. Of course, there are the delays in obtaining sanction.
An important file getting misplaced is there
not misplaced, but certain papers and certain documents. Part of the send was sent to the RO, part was sent to the divisional office. So therefore, because of that, we could not have the complete access to the file at the moment for obtaining such sanctions from the competent authorities, because the file has to be examined by several officers of the insurance company.
Pay cost.
Or at least, had it been there a deliberate attempt.
Heard the counsel for the appellant and heard the counsel for the respondents on this limitation, on the application filed under Section 5 of the Limitation Act. There's a 403 days delay in filing this appeal. Next one. Counsel appearing on behalf of the appellant submits that the entire file in relation to this case got misplaced in transit from one office to another, resulting in this delay. He submitted that opinion had to be obtained from the panel lawyer and the file was sent to regional offices, and further paperwork were to be done in the legal cell, which consumes some time. What's the next para? Considering the submissions made therein, that I find that there are some latches on the part of the insurance company in filing this appeal, but considering the issue involved and the delay
But may I
and
suggest one thing? May I suggest one thing, Your Lordship? May I suggest one thing? In this appeal,
switch on your microphone.
in this case, we have been given a right of recovery against the owner. And the only thing which we are harping upon is the conventional weight, which is very high. So that is for your Lordship's consideration.
First, I have to allow your application under order.
That is true, Manoj, but the only point which we are harping upon is the conventional height 2,25,000 instead of 70,000.
Considering here the issue, the disputed issue in this appeal, I'm inclined to allow this IA. The IA is allowed, but with subject to a payment of cost of rupees 5,000 by the insurance company, appellant insurance company, to the claimants.
But we'll deposit in the before the Registrar General Jharkhand High Court.
No. You serve upon through a lawyer, through the lawyer of the claimants.
Ms. Satakshi, you are appearing. Ms. Satakshi, you are appearing for the claimants.
Yes, sir. Yes, sir.
Okay.
Call for the lower court records. Unless this case under the hearing for admission.
Serial number 40, MA number 48 of 17.
Yes, Mr.
But
Lal.
in this case, also the limitation application is here for condoning delay of 153 days. In this case, there was a no driving license and the permit, but although the tribunal has drawn the adverse inference, but no right of recovery has been given.
Who is 5? Respondent number 5?
5 used to be the owner, Your Lordship, Vicky Kumar.
As per the office note, notices have been validly served upon respondent number 5, the owner of the vehicle. Full stop. Next para. There's a 153 days delay in filing this appeal. The reasons for delay has been mentioned in paragraph 4, 5, 6, 7, 8. And 9 of this appeal. Considering the aforesaid submission, I am inclined to allow this IA. This IA allowed. Let this case under the hearing for admission. Call for the lower court records.
Serial number 50, MA number 384 of 17, Mr. Amresh Kumar for the appellant.
In this case, Your Lordship, I am on behalf of the appellant. Notices has been issued on 22/6/2018. One has appeared, Your Lordship, name is one, counsel is appearing in the cause list.
I am appearing, Lordship, for respondent number 2, who is the owner. And most importantly, Lordship, I have
Yes,
also filed one petition, one appeal for enhancement on behalf of claimant. Number is, Lordship, MA number 75 of 2019. Both may be tagged, Lordship.
Then the counsel is appearing for both the party, Your Lordship.
You are appearing for the owner and also the claimant.
No, I am for the claimant, Lordship. I am for the claimant. Only for the claimant. Karthik Pandey.
is
sorry, Lordship. Sorry, I made wrongly I have stated, Lordship.
Here, the claimant has appeared. Full stop. Let fresh notice by ordinary process be issued to respondent number 2, the owner of the vehicle. Requisites. Full stop. You are praying for recovery.
Your Lordship, I am for the first and the liability, Your Lordship, the DL, which was post one, and I have also exhibited 2 letters, but in the judgment is not considered, Your Lordship.
Call for the lower court records.
Applies.
It may be tagged, Lordship, with MA number 75.
Is this along with MA number
75 of 2019.
75 of 2019?
All right, Lordship.
Serial number 16, MA number 414 of 17, Mr. Chandranjeet Mukherjee for the appellant.
I am appearing on behalf of the appellant, Your Lordship.
Yes.
Notices were issued on 29/4/2019 and thereafter appearances have been marked by them. Your Lordship, it has come on IA for the release of the amount and IA for limitation.
Notice has been validly served on respondent number 3. Full stop. IA number 59999 of 2017 is on record. Is on board. Full stop. There's a delay of
148 days, Your Lordship.
148 days in filing this appeal. The grounds have been mentioned in paragraph
4 onwards.
4, 5, 6, 7. First up, considering the said submission, this IA stands allowed, delay condoned. What is the other IA?
IA is for the release of...
Milord, I am appearing on behalf of respondent number 1 and 2, claimant, Milord. One IA is also there, seeking permission to withdraw the amount. But the checks have been deposited by the appellant insurance company. However, it expired.
Your Lordship, 2 checks were deposited on 5/4/2018 for the sum of rupees 27,15,417 and sum of rupees 1,12,594.
Who was the beneficiary of the said check? In whose name?
Below, the checks were in the name of respondent number 1, claimant, and 2.
So the check was not encashed.
No, my lord. Because as per the order of this honorable court, it has been ordered that learned court below shall not disperse the awarded amount till further order.
Your Lordship, इसमें एक चीज कहना था, sir, कि we are also challenging the quantum. The entire award has been deposited as by.
Look at the IA number. IA number it will be
1606.
1606 of 2019 has been filed by the claimant, bring therein to allow them to withdraw the amount which has been deposited before the tribunal, pursuant to the order dated 5/3/2018. During course of argument, it has been brought to the notice of this court by the counsel appearing by the parties that checks were deposited before the tribunal, and the check on
It was deposited on 5/4/2018.
5/4/2018 in favor of the claimants, and First, favor of the claimants. Full stop. Next para. The order dated 5/3/2018 directed the insurance company to deposit the entire awarded amount with interest before the court in the court below. And there was a further restriction to the effect that the amount will not be disbursed till further orders. Full stop. As check was deposited in the name of the claimants, which the validity of which has expired, this and the same and the expired. Full stop. This court is of the opinion that this means that no amount is in deposit with the court till date. Full stop. Thus, the IA is rendered infructuous. Further, it is observed that since the money was retained by the insurance company and has not been disbursed or paid to any of the parties, the insurance company will also be liable to bear the burden of interest for this aforesaid period also, for this aforesaid period. Call for the lower court record, place this case after 2 weeks. Full stop, comma, if possible, the entire appeal can be disposed of at this stage. Wait for 2 weeks, Mr. Karan.
Obliged.
If the entire appeal can be disposed of, then it's not necessary.
Milord.
Your Lordships, if interest part, because we complied with the orders of the court, Your Lordship, long back on 5.
What sort of compliance is this, madam? This is hoodwinking the court. I give you a check with a rider, it cannot be withdrawn. That means the amount has gone out from your account, or you are enjoying that amount. Tell me.
No, it hasn't gone out.
Then
it hasn't gone out from.
Then why will not pay interest for the amount which you have, which was with you?
Lordship.
Yes, next.
Obliged.
Number 70. Number 438 or 70. Mr. Vijay Kumar Sharma.
Yes, Mr. Sharma.
In this case, I am for the respondent insurance company.
I am respondent number 1, Lord.
For enhancement with a right of recovery to the owner insurance company.
There is the appellant is not there. Insurance company has appeared, owner has appeared.
Yes, I have appeared in my owner. I do not know whether the owner is appearing or not.
Mr. Rajesh Singh, you are appearing on behalf of whom?
Driver of the vehicle, Lord.
Driver, where is the owner?
Respondent number 1.
Where is the owner?
Who are driving the alleged vehicle accident at the time of accident.
Who is the owner?
I don't come there to who is the owner.
Just a minute, I'll tell you. I'm coming to that.
Yeah, that the
owner is deleted. Owner's name at page there was 3 has been deleted. I do not know why. Shravan Kumar Yadav. Shravan Kumar Yadav, respondent number 1, is the owner.
Shravan Kumar Yadav is there. It's not been deleted.
No, he is deleted from the cause title of the area of the parties in the memo of appeal.
Rajkumar. Who is you are on behalf of Rajkumar?
I am appearing Shravan Kumar.
Shravan Kumar. Then you are one. You are the owner of the vehicle.
Then he is the owner.
You are the owner of the vehicle. Okay, the owner of the vehicle and the insurer of the vehicle has already appeared before this court by filing wakalatnama. We'll stop. Next line. Today, the counsel appearing on today the counsel for the claimant is absent. We'll stop. This case next week.
Serial number 18, MA number 447 of 17, Mr. Aloklan for appellant.
But in this case also, the matter has been placed before Your Lordship. The notices were issued. Some of them have appeared. I do not know what is the status of
1 and 2
notice.
has appeared.
Yes,
1 and 2 has appeared.
2 has appeared. I am concerned with the owner. He is
1
owning
and 2
the-
has appeared.
1 and 2 appear. Then the owner. Then in that case, my lord, the
Two has appeared.
application has been placed before Lordship for condoning a
Is
delay.
appearing on behalf of the respondent 1 and 2? Mr. Verma, unmute yourself. देखिए देखिए, who is appearing? Just check. First check. Mr. Verma is appearing on behalf of Gullu Soren. Who is Gullu Soren?
He is a claimant.
And Mr. Gautam Kumar appearing on behalf of
Manoj Kumar Bhagat.
Manoj Kumar Bhagat.
He is the owner.
Okay. Yes, Mr. Verma, unmute yourself. Mr. Verma, unmute yourself.
Your Lordship.
Yes, yes. There's a delay.
I'm the claimant of the claimant, Lordship. The elder brother of the claimant is died by the vehicle, Lordship. And vehicle is insured. Lordship.
There is 35 days in. The 35 days delay in filing. Full stop. This petition has been filed under Section 5 of the Limitation Act, praying therein to convert the delay. Full stop. After going through the application, especially paragraph 3, 4, 5, 6, 7, 8, and 9, 10, and this court is of the opinion that the delay has been sufficiently explained. Full stop. IA allowed. Delay condoned. Place this case under the heading for admission. Call for LCR.
Serial number 19, MA number 457 of 17, Mr. Manish Kumar for appellant.
My lords, this is a case where there is delay, my lords, but if I may permit me submit, my lords, delay may be condoned, my lords, because the case can be disposed of at this stage itself. Ground is, my lords, quantum. The assessment is 6,000 rupees per month against the claim of 9,000 rupees. We have challenged that it should be 3,000 rupees and enhancement has been given at 50%, it should be 40%. But when I calculate the award, my lords, even on 40%, there is a difference of around. No, what I'm submitting a different thing, my lords. I'm saying that even if I calculate it at 40%, the amount will be reduced by, my lords, some of
Not on 40%. Annual income of the deceased was assessed at 6,000. What was the claim?
9,000 was the claim. Therefore, I am saying, my lords, 6,000 was considered. It is accident of 2013, my lords.
So you are not challenging that assessment of income, annual income?
No, I am challenging, my lord, because in the appeal, the ground is that it should be 3,000. What I am saying is in the changed circumstance, my lord. Not even if I succeed in my appeal and 6,000 remains there, there will be benefit of 74,000. And there is very little chance of that. Because
what was the vocation of the deceased?
They are claiming, my lords, that
supply vegetables.
Yes, that he was working supplying vegetable also, as well as just about my sample.
At least I need the LCR to come to a finding.
Cycle repairing shop. He was running a cycle repairing shop.
I need the LCR also. लिखे तो I number
should be issued, my lord, because claimants have not appeared.
Let's see. Let's see.
Let's see LCR come.
While dismissing your appeal also, I need the LCR to come to a conclusion.
Yes. Let the LCR come.
Issue notice to, no, not notice. IA number so and so. In view of paragraph so and so, the delay is condoned. List this case under the heading for admission Call for the lower court records.
May I submit one thing, my lord? Let the IE also remain pending, my lords. Because if the bench changes, then there will be, my lords, something change circumstance. Therefore, I am saying, if something happens tomorrow, another bench comes, then they will not be able to, my lords, appreciate what I have submitted for your lordship. Therefore, I am saying.
Are you the person who is in charge of changing the bench?
No, no.
Then what gives you that idea?
No, not that idea. I am only saying that let the IE also be pending because they have not appeared.
Is delay control.
Yes. My lord.
The LCR.
Obliged. With discretion of your lordship.
Don't dare to make these type of submissions.
No, man. I'm sorry, man. I did not intend to say that. No, I retract my statement.
Cannot now. It's recorded.
I apologize.
It's recorded. It's recorded now. Yes. Next.
Serial number 20, MN number 467 of 17, Mr. Virendra Kumar, for appellant.
Claimant prefer this appeal for enhancement lordship.
Yes.
And there is delay of stage in filing the appeal.
How many days?
14 days. What for?
Who is the insurance company?
I have to copy the insurance company, any of the Sri Manish Kumar lordship. To copy.
Have you served?
Or anyone lordship. As lordship advice.
Sir, why should I advise you? I'm not there to advise you. You can serve a copy upon the National Insurance Company Limited. If any lawyer of the National Insurance Company Limited is in the panel, please volunteer to accept the notice.
I shall copy to the Sri Manish Kumar lordship.
No, I will accept, my lord.
Okay, Manish Kumar accepts notice on Mr. Manish Kumar accepts notice on behalf of respondent number 1, National Insurance Company Limited. We'll stop. Next line. Mr. Virendra Kumar, learned advocate, will serve a copy of 2 copies of this memo of appeal along with the judgments, along with the impugned judgment in the office of Mr. Manish Kumar. List this case under the same heading after 2 weeks, when the IA for filed under section 5 of the Limitation Act will be considered.
Serial number 21, MN number 476 of 17, Mr. Alok for appellant.
But in this case, I am appearing for the appellant. The limitation application has been placed before a lordship after the due service of notice, and in terms of order at 5/10/17, I was directed to deposit rupees 2,550,000, which seems to have been deposited before the court below. Delay is about 60 days.
Notice has been validly served upon respondent number 6 by substituted service.
On 10/10/17, the notices were filed, but I'm not aware of the status because it seems that a battery of lawyers are appearing.
Validly served as per the office note. As per the office notes. Who is respondent number 6? What is the name? As it is apparent that Kamaleshwar Sahu has himself. Next one. Who is for the claimant?
Lordship, I am appearing on behalf of
How many
respondent
days?
number 1.
How many days? 60 days delay.
60
Yes,
days,
Lordship,
that's my
60.
calculation.
60 days delay, stanza 5, it's allowed. Call for the lower court records and list this case under the hearing for admission. What is your ground, Mr. Lal?
But in the case there was an accident caused by the motorcycle and the motorcyclist was not having a driving license. That is the only ground.
Contributory negligence.
No, motorcyclist.
No.
He was not.
The motorcycle is the offending vehicle.
Yes, bicycle. He was in a bicycle. I cannot say that.
Motorcycle is the offending vehicle.
Yes, I cannot.
This
say
is
that
was going on a bicycle, through bicycle.
So I cannot say that he was also negligent. I cannot take that.
No, I thought that the motorcycle was hit by some other vehicle.
No. He
was going through bicycle and the motorcycle hit him.
Is the offending vehicle. Okay. So you want right to recovery?
Only to that extent, nothing beyond that. under present scenario.
Okay.
But subject to correction by your lordship, my lord, the one judgment with Mukund Devangan,
It has been referred to the larger bench.
a constitution bench.
Yes, it has been referred to the constitution bench, but
And apart from that, in that case, I have been informed.
Mukund Devgam is on the point of Mukund
LLB,
Devgam
LLB endorsement, LLB endorsement.
weight of the vehicle.
Yes, but in that case, as I've been informed by the counsels who are appearing in those cases of the set of lawyers and the insurance companies, that other issues that with regard to the right of recovery and other things, all the issues which are being left for the court to be decided in latter stage, that has also been wrecked up.
So maybe it has been wrecked up, but the judgment has not been stayed.
No, it has not been stated. It is clearly stated.
Till different view comes from the Honorable Supreme Court, this view will prevail.
Yes, that is specifically written in that reference. That by that time, the previous the right of recovery will operate. That is the last. So therefore, that has not been stated. No interference has been made on that issue.
Serial number 22, MA number 93 of 20, Mr. Faizur Rahman for the appellant.
There are two IA before your lordship also. One is for knowing the delay and one for stay of the operation of the team daughter. And delay is of 25 to 55 days, your lordship, as pointed out by the resti. And I have stated why the delay was occurred, your lordship. It starts from para 7 onwards, your lordship. As because the office is situated near Myanmar border, your lordship, Indo-Myanmar border within the state of Manipur, and the files has to be routed in different places, your lordship.
How many days delay?
55 days, your lordship.
How much?
55 days, as per pointed out by the
255 days. 255 days.
255 years.
Who is for the claimants? Respondent number 1.
Notice has to be issued, your lordship. And today was the date fixed for disbursement of the amount, your lordship. We have already deposited 12,90,399 suo moto, my lord. And the delay was not intentional, your lordship. We have sent several times notices to the Deputy Commissioner Labor District Khuti to send the address of the personal, your lordship, and thereafter to again through SP, Deputy Commissioner Khuti, your lordship. At last, we have deposited the amount before the Labor Court Ranchi, your lordship.
What was the compensation amounts?
Suo moto we have deposited, your lordship.
What you have deposited, what is the compensation amounts? As per you?
My lord?
As per you, what is the compensation amount?
Only for interest part we are here, your lordship, before your lordship.
What is the as per you? Except the interest, what is the amount of compensation?
That was, your lordship. Just I am 12,90,319, your lordship. And at page 109, your lordship, the learned court below has given his finding. Accordingly, I find that the applicant Jini Devi is entitled for the interest at the rate of 12% on the entire compensation amount rupees 12,90,390.
How much you have deposited?
12,90,000.
How much amount you have deposited?
12,90,319 rupees, your lordship.
That has been disbursed.
No. That has been disbursed, your lordship. That is by stay petition, my lord. Just I am saying, your lordship.
IA number?
IA number, my lord, 2030, your lordship. 2030, my lord.
Let's see what I will see. Compensation.
My lord.
This is under the Employees Compensation Act.
Employees Compensation Act 1933, your lordship. Section 4A 3AB.
4A.
Yes, your lordship. 4A says, your lordship, compensation to be paid when due and penalty for default. 4A false due. Now, false due, your lordship. The learned court below has given the crucial expression is false due. Significantly, legislature has not used the expression from the date of accident. Unless there is an adjudication, the question on an amount falling due does not arise.
No. There's no question of adjudication. See, you had deposited the amount of 12 lakhs.
Yes, your lordship.
That means you knew that 12 lakhs is payable.
My lord.
You should have deposited it immediately. So where is the question of adjudication in this case when your adjudication, Mr. Rahman, adjudication will be when there is a dispute in respect of quantification. But you yourself say that yes, 12 lakh rupees is entitled. If he says, just a minute, if he says, if he disputes that 12 lakh and says no, the original amount will be 15 lakhs, then there is a dispute of 3 lakhs. But so far as 12 lakh is concerned, there is no dispute.
ये एक्सीडेंट के टाइम से मांग रहे हैं जबकि होना चाहिए from not the date of accident.
When will the amount fall due? Tell me.
That is why may I be permitted to read for 3AB, lordship?
Yes.
Compensation in cases where the employer does not accept the liability for compensation to 4A3, lordship. Where any employer is in default in paying the compensation due to under this act within 1 month from the date it fell due. The condition
when does an amount under the Workmen's Compensation Act falls due?
When the application is filed, your lordship.
No.
Yes, your lordship. My lord, B, in his opinion, there is no justification for the delay. That, and there is justification. I have given the justification, lordship. Why delay occurred, your lordship? Occurred.
Tell me first.
That the employer provided, my lord,
Now, have you deposited this 9,56,000?
My lord, provided that an order for the payment of penalty shall not be passed under clause B without giving a reasonable opportunity to the employer.
That is a different aspect. That is a different aspect. Now the court, just listen to me. The court has directed you.
Court has directed
amount of rupees. How much?
Court has directed me accordingly. I find that applicant Jingi Devi is entitled for interest at the rate of 12% on the entire compensation amount of rupees 12,90,319 from the date of accident, that is 25/3/2013, till payment date, that is 6/5/2017 in this court. So accordingly, petitioner is entitled for rupees 6,32,256 as interest. Applicant is also entitled for rupees 3 lakhs as penalty as without sufficient reason. Delay has been by the party.
If you notice to the claimants, respondent number 1 on the limitation matter and also on the stay petition. Full stop. Considering the submission made by the learned counsel for the appellants, the part of the order dated 5/4/2019 passed in miss case number 45/17 within bracket capital F by the presiding officer Labour Court Ranchi to the effect which directs payment of compensation by way of which directs payment of 50% as penalty that is to the tune of rupees 3 lakhs is kept in abeyance till further orders. Requisites both process 2 weeks. I have stayed only the penalty part.
My lord, oblige your lordship.
Not the interest part. Not the interest part.
My lord.
Next. Yes.
And then password matters. Serial number 12, MN number 54 of 17, Mr. DC Ghosh.
Yes, Mr. Ghosh.
My lord. If my lord permits, my lord, due to importance, my lord, I have not marked the case. Just after 1 day, it may be taken.
45 days.
Ready with it.
45 days delay.
Delay is 45. Delay is 45 days.
I am on
Delay is
delay.
45 days.
I am on delay. Yes, Mr. Banerjee.
Yes, on delay, I have no. Delay, yes, it can be condoned.
IA number so and so, delay condoned. In view of the statement made in so and so. List this case under the heading for admission. Low court record is here? No. Call for the low court records.
No.
I'm calling for the low court records.
My lord. My lord.
Yes, yes. Lordships, after receipt, if some date is fixed, since nothing has been paid till now,
it will be listed.
Matter of 2013.
Don't worry, the cases will be listed, and cases are being listed. In fact.
As well.
Yes, yes.
Yes.
Obliged.
For the heading for admission, serial number 23 with serial number 24, MN number 339 of 15, MN number 282 of 15. Mr. Arvind Kumar Lal for appellate in first case, Mr. Alok Lal for appellate in second case, Mr. Alok Lal for respondent in first case, Mr. Vishu Ranjan, Mr. Arvind Kumar Lal, Mr. Sanjay Kumar Singh, Mr. Sahil for respondent in second case.
My lord, this case is injury case.
Yes. One more thing I would like to bring you to your lordship's notice that in my case it seems that the owners, they have entered their appearance. In my case, in the case of my case, but in case of Mr. Arvind Kumar Lal, perhaps the status of notice, I do not know what is the status of notice. Because owner is none else than the father of the claimant.
Who is appearing?
Like in the case of collision of two vehicles.
LCR is here?
LCR was called for your lordship.
Yes. First, let us hear Mr. Alok Lal.
No, Mr. Arvind Kumar, his case is the first.
No, because Mr. Alok Lal.
Yes, I'll make submission. I'll start. Don't worry. I'm ready.
Who is appearing for the owner? Okay, yes, Mr. Lal.
Yes, but in the brief summary, this case is that the son of the owner, who is the appellant before your lordship in the first case, he was moving in Maruti van behind one vehicle which, subject to correction by bylaw defendant, has not been added as a party. Now, it is alleged that because of the rash and negligent driving of the vehicle moving ahead of him, this vehicle met with an accident causing him very grievous injury, making him render. Now, my contention before your lordship is, first of all, your lordship, what I would like to submit in a very significant manner and the forum for the map reasons best known to the claimant. Kindly see, there are certain errors which have been specifically we have assailed. The accident was at Bhojpur. This claimant claims to be the resident of, kindly see the cause title error of the address portion. He seems to be the resident of Bokaro. Now, he has given an address of Ranchi. I would not like to name, but kindly see the name. Because that gentleman is no more, and I have inquired from his son also that he is not aware of anything. So we have very specifically and categorically taken this stand in our written statement also. Of course, there is no bar, but there has to be residence of the owner in show claimant. This is not his permanent resident. My lord may inquire it from the son of the person who has been named as a care of.
Why should this court be in this?
Yes, that is true. That is true. But this, in the very big itself, creates a doubt with regard to the claim. Why it has been filed purposely in Ranchi when no cause of action has arisen, neither he is residing at Ranchi, nor he is anyway related to that gentleman or the family of the gentleman who is no more perhaps.
Now, is there any bar? Is there any legal bar?
No, there is no bar. There is no bar. No, there is no bar.
If there is no legal bar, please don't.
There is no legal bar, but this itself creates a doubt how this claim has been manipulated.
Mr. Alok Lal, if I have to answer this issue that on this ground there is a manipulation, then I have to hold that there was a bar. He was stopped from filing.
What I am submitting, there is no bar. There is no bar.
If there is no bar, why are you making this submission?
Because we have taken this ground in paragraph 4 of our written statement. That was specifically pleaded in paragraph 4 of our written statement. Now, kindly come to the manner of accident I have narrated.
Which is legally acceptable.
Now, kindly come to issue number 6, which has been decided, and a contributory negligence. Kindly come to paragraph 9.
This vehicle which met with the accident was behind the what is the other vehicle?
Maxi taxi.
Maxi taxi.
Yes.
So maxi taxi took a sudden turn. As a result of which this vehicle dashed.
Yes.
The maxi taxi and the driver, who happens to be the insured himself and the owner of
No. This is not the case.
Then
it is not the case here.
Then
it is a case that the claimant was driving the car of his father. He dashed from behind with the maxi taxi. Allegedly, that maxi taxi was rash and negligent. Now, I will demonstrate from the documents itself that he is not a third party, cannot claim any compensation. There are several judgments on these issues. So he cannot be a third party. He is the son of the insured owner. It is not the case that maxi taxi is the made.
Maxi taxi was not made a party and no claim has been made against the maxi taxi.
Nothing. The liability has been fixed upon me, the insurer of the vehicle.
No. Wrong submission. Liability has been apportioned between both the parties.
Both the
Both the
parties,
parties. Yes.
but so far I am concerned, I am not liable.
No.
I am
Just a
concerned, I
minute.
am not liable.
Where is the apportionment, Mr. Lal? Arvind Lal?
Yes, my lord. Kindly see, my lord. That is in para 24 of the judgment.
Para 24. Yes.
24 and 25. It is therefore ordered that the claimant, namely Jyoti Prakash Pandey, is entitled to rupees 6,62,000 in total, out of which 80%, that is 5,29,600, shall be paid by OP number 1, and the balance 20% of
Who is OP
1
number
lakh.
1? Who is
OP number 1 is the owner of the maxi taxi. The vehicle is perhaps not insured, and
Yes.
till date we are not knowing that whether vehicle was insured or not.
Okay.
And insurance company is the insurer. This insurance company is the insurer of the car.
Yes, I admit the insurance. But for me, you are not a third party.
That liability has not been fastened upon the insurance company.
No, the 80% upon the insurance
upon
company.
me. For his,
No.
for his own
20%
negligence.
upon the insurance company.
Or 20% upon the insurance company.
Yes, my lord.
Who is the owner? You first decide. Owner is his father.
Surya Singh.
Surya Singh is the owner.
Yes.
He's the owner of the maxi taxi.
Surya Singh is the owner of the maxi taxi.
Maxi taxi.
Yes.
Chandra Kishore Pandey is the father of the claimant.
Yes. Is the registered owner of the Maruti car.
Maruti car.
Mr. Alok Lal, you are the insurer of the Maruti car.
Yes, I am the insurer of Maruti car. So my
Your
contention
liability is 1,32,000.
20,000. So my contention is before your lordship that
1,32,000.
20%. Yes. My contention before your lordship that he cannot claim any compensation for the negligence first, negligence on the part of himself rationally driving. Secondly, he is not a third party. For me, he will step into the shoes of his father. Nothing beyond that.
Let us see where is the issue of contributory negligence
That is
decided.
issue number 6.
Yes.
Issue number 6 is discussed at
Para 22.
Para 22.
Internal page 6.
Yes.
Para 22 at page 6.
Read that.
Issue number 6, which relates to the composite negligence. In this case, the insurance company, that is OP number 1, OP number 3, has stated that on going through the FIR and charge sheet as well as evidence which has been brought on record, the accident took place on account of negligence on behalf of the driver of maxi taxi. Therefore, no liability can be fastened upon OP number 2. It is not the case of composite negligence. On perusal of the record, documents which have been brought on record categorically says that the driver of maxi taxi was driving the vehicle negligently, but the accident as a result of which one Maruti van as well. As per the words used under section 165 of the MV Act, apparent that the Maruti van owned by OP number 2 was also in use and accident was the result of the use of vehicle as well. Under such circumstances, in this case, the liability of two vehicles, maxi taxi and is apportioned 80 to 20, 80 into 20, 80 and 20%. Now here I will pause for a moment. If he was also negligent, then when can claim a compensation on account of his own negligence? Firstly. Secondly, he was driving or riding in the car of the father who was insured himself. Therefore, if these two things are taken together, I am not liable to pay even a single rupee. That is my contention.
What are the judgments you are relying upon?
Well, there are certain judgments which I will rely upon, my lord. The first in this case would be, I'll giving the reference, my lord, because AIR 2009 Supreme Court 1788 Sadanand Mukhi.
AIR
2009 Supreme Court 1788 Sadanand Mukhi.
Yes.
And there is one Ram Khiladi, recent judgment of 2020, volume 1, JLJR, page 272.
2000?
2020,
Yes.
volume 1, JLJR, page 272, Supreme Court. And there are others also, Malot. The United India Insurance Company versus Magan Bhai, Darak Bhai.
What has been held in these two judgments?
Yes, Lordship.
What has been held in these two judgments?
Malot, just I'll take out the copies, Malot. I'll take out just the copy. Kindly, but in the meantime, let Mr. Arvind Lal submit. I'll take out all the judgments.
Submit. You tell that your argument is over. Then only Arvind Lal will submit.
Now, Malot, in this case, for own negligence, one cannot claim the compensation. Number one, in Ram Khiladi case, the law is that he steps into the shoes of the owner as the borrower. So therefore, he cannot claim any compensation save and except what has been taken under the package policy, that is 1 lakh. So in this case, the policy which, if as per the record which I am having, the records have been called for. Kindly have a look to the policy.
The counsel appearing on behalf of the appellant insurance company in case number so and so argues that it is an admitted case that the tribunal found that the liability of the claimants, liability of the liability of the contributory negligence of the vehicle which was insured by the appellant is to the tune of 20%.
20%.
He submits that when there is a contributory negligence of the owner of the vehicle itself,
driving the person driving the vehicle,
whose son was in fact driving the vehicle, yes. The claimants are not entitled for any benefit from the insurer of the same vehicle. He further submits that in this case, admittedly, the son of the owner of the vehicle was driving the vehicle, which met with an accident, and the tribunal has apportioned contributory negligence to the tune of 20% upon him. He submits that in this case, in this type of cases, where the son of the owner was driving the vehicle, it cannot be said to be a third party, and thus is not entitled for any compensation, as he will step in the shoes of the
insured
actual owner of the vehicle. What's up? Next paragraph. Considering these submissions, both these appeal will be heard. Admit.
In this case, my lord, may I submit one thing? Rupees 1,32,000 rupees has been ordered to be deposited in the tribunal, but not allowed to be disbursed. Let the same be allowed, my lord. It was stated.
No. If the answer, if this question are answered in favor of the insurance company, you are not entitled to anything from this.
Very correct, my. But there is no finding of contributing negligence. Composite negligence.
Then why
20%
was apportioned to you?
Composite, not contributory negligence. It is a word composite negligence and arising out of use of the motor vehicle under section 165.
But I will see that whether there was a contributory negligence or not.
That is correct, my lord. But the court's finding is composite negligence, not contributory negligence. Contributory negligence is something else.
In what manner the accident had taken place?
And in this case, my lord,
Even if it is use of the motor vehicle, can you take, as per Mr. Alok Lal, that he will not be a third party?
He is a third party. Other than owner and insurer, everybody is a third party. Entire world is third party other than owner and insurer. And it is not a case of that the insurance policy was a third party policy. Had it been a third party policy, that matter would have been otherwise.
The amounts are deposited before the tribunal pursuant to the order dated.
My lord.
28/8/18.
28/8/18 should be kept in an interest bearing account by the tribunal.
My lord.
Next.
Serial number 25, MA number 340 of 50, Mr. Arvind Kumar Lal for the appellant.
Yes, Mr. Lal.
My lord, this is for enhancement of the awarded amount of compensation, my lord.
Okay, let us see.
So this is was 48 years old, my lord.
Who is,
He
who
was
is the insurance company? Reliance General, who is appearing?
I am appearing on behalf of the insurance company, Your Lordship, and pay right to recovery has already been granted by the learned tribunal. Lordship, we had also made an offer.
Who is for the owner? The owner? Who is owner? Respondent number?
Owner is my lord. Manohar Ram, respondent number 1.
Respondent number 1 is the owner.
Yes, my lord. And respondent number 5 is also owner. It is a case of collision of two vehicles. Bajaj Platina and one is Tata Magic.
Manohar Ram is the owner of the offending vehicle, Your Lordship. He is respondent number 1.
And respondent number 5, Pitambar Prasad Yadav, is also owner of another vehicle, that is Bajaj Platina motorcycle.
So who was directed to pay the amounts?
OP number 1, Your Lordship. We have been directed to pay and right to recovery from OP number 1. That is owner from
OP number 1 has already appeared. So okay, yes, Mr. Arvind Lal, let us see. What is this?
My lord, in this case, my lord, the deceased was 48 years old, my lord, and he was an assistant teacher in private school, and he was also LIC agent and was also commission agent of Sahara India, and he was earning 12,000 per month on the basis of the court below, my lord. But as a matter of fact, kindly see, my lord, regarding income, page 12 of the judgment, my lord. Page 12 of the judgment. In respect of the quantum of compensation, it has been claimed in the claim petition that deceased was aged 48 years and was your assistant teacher, the agent of LIC India, the agent of Sahara India, and he was also shop owner of food grain, Pichli Post Dukan. It is also been claimed in paragraph 6 of the claim petition that he was earning 33,000 rupees per year.
Mr. Arvind Lal, if a teacher is doing all these type of jobs,
he was assistant teacher in private school. They are getting very bigger.
You were not teaching properly. You were not teaching properly.
My lord, in private school, my lord, very few, meager amount is being paid.
How much?
So
How
in
much?
order to make livelihood,
How much paid? Salary as an assistant teacher?
he was getting, my lord, 33,900 per annum.
Per annum?
My lord. Not per month. गांव का जो प्राइवेट स्कूल जो होता है.
What are the documents you have produced? Let us.
In this case, my lord, the court has considered, my lord, 5,000 per 5,160 per annum as salary, and this is was earning commission agent 27,834, and further this is was earning 29,043 as commission from Sahara India agent, and was earning 12,000 from food grains. In this way, yearly income of the deceased was in total 74,037. After deduction 1/3 amount towards his personal expenses, his annual income can be assessed at 74,000. But no consortium has been given, no future prospect has been considered, my lord.
Let us see the evidence which you have led.
My lord.
Let us see the documents.
I'm not aware whether lower court record has come or not.
Yes, it is here. Yes, tell me what are the documents you have exhibited.
My lord. The documents, my lord, the and the commission of LIC, commission of Sahara India Parivar.
This is also this claim must be based on some documents, because there are documents in support of that.
My lord.
Yes. What is it?
That is exhibit, my lord. Exhibit 17, exhibit 16, 17.
Exhibit 16. What is 16? Insurance commission.
My lord.
Date of accident?
Date of accident is, my lord, that is 6/6/2010. Exhibit 15, 16, 17.
What is the total amount of commission?
The total amount, my lord,
for LIC?
As per the court finding, my lord.
How much?
It is 27,834
Yearly.
yearly.
From LIC or from Sahara?
Sahara 29,043.
That as per court's finding.
Yes, my lord.
This is as per the evidence which you have brought. There is no dispute in this.
Yes. And 12,000 from food grain shop.
No. And from LIC, how much the court has considered?
27,834.
There is no dispute in this also.
My lord.
Yes? Are you disputing these two amounts?
No, I am not disputing.
You are not disputing these two amounts?
Yes, my lord.
Okay. The grain shop also, you are not disputing that?
My lord.
Then what are you disputing? The school fees?
That future prospect?
The school fees. School fees also you are not disputing?
But in school, my lord, because as per the document, my lord.
Which document?
I have not gone through that, my lord. I'll just see. Because if 33,000 rupees he was getting as salary from assistant teacher per annum. Therefore, my lord, the court has considered as 5,160 per annum.
Where is the food grains you were having a grocery shop, private grocery
Yes.
shop?
वो गांव देहात में जो छोटा दुकान होता है उस टाइप का.
What was the income from that?
The court has considered 12,000 rupees per annum, 1,000 rupees per month.
Okay, no problem. So now what is the dispute?
That is, future prospect has not been given, consortium has not been given, funeral expenses 2,000, loss of estate only 5,000 has been given.
Only this, you are not challenging the assessment of your income.
And that income from the school.
So
Because 33,000 was my evidence, and
Yes.
the court has considered 5,000.
Show me the documentary evidence. It was 33,000.
My lord, just a minute, my lord. Kindly. School certificate is here.
Where is that document?
My lord.
ये लॉर्डशिप एग्जिबिट 26 है जिसमें बोलते हैं कि 430 rupees per month was given in the month of April. That has been exhibited by him only.
26.
The salary register, yes, exhibit 26.
Where is this 26? Exhibit 26. 22, 22 by 1, 22 by 2. Yes, yes, there is something. What is this? What is the date of accident?
Date of accident, my lord, is 6/6/10.
No. This exhibit 23 cannot be taken into consideration. Show me anything, any certificate which was issued during your lifetime. Show me any certificate issued by the school authority during your lifetime.
My lord, just I'm going to the list of exhibits, my lord.
Lordship exhibit 26 may kindly be seen. Exhibit 26, the payment register, has also been produced on behalf of the claimant. It appears that from perusal of Exhibit 26 that according to the payment register, the deceased B.K. Yadav has received only 430 in the month of April, May ka accident hai, Lordship. This was the last amount which was received on 4/5/2010. Hence, on the basis of Exhibit 26, the claimant failed to prove that the per month income of the deceased was rupees 2,575 rupees. And
That
he
was
was
the last.
given 15,000 as bonus in the half yearly. That I'm reading from the impugned judgment itself, page 12, Your Lordship. Second para.
Because he was not in regular employment, my lord. He is regular, matlab, in government job. Therefore, for working days, he was getting salary. In the month of May, this is the of May, due to summer vacation, जो भी काम करेगा उसी के मुताबिक मिलेगा, लेकिन he was entitled to that sum.
That means
it cannot be less than a labor.
No. What less than labor? You are this is something fishy, Mr. Counsel.
Your Lordship, 2010 में 6,169 has been considered by the learned tribunal for his monthly income, including all the exhibits and the documents that has been produced by the claimant themselves.
His attendance registered is also on record, my lord.
What is the name of the deceased?
Name of the deceased was Basudev Kumar Yadav.
B.K. Yadav.
My lord.
April.
His attendance is in Exhibit 25.
He died on? When did he die? What is the date?
My lord. 6/6/10.
6/6/10.
My lord. He died during the course of treatment, my lord.
When did the accident take place?
Just excuse me, 1 minute के लिए हम.
On the same date, Your Lordship.
My lord.
Okay, we'll hear it further on Monday.
My lord, till Tuesday I am not here, my lord. Therefore, any day after Tuesday, my lord.
On heard in part, list this case on
Wednesday.
Wednesday.
Yes, my lord.
Wednesday.
That is on 6th. 6th.
Lordship.